Welcome, everyone. Thank you so much for joining us today in this presentation. My name is Jiyae Hwang, and I am a senior associate at Scott Legal PC. And today we're going to spend some time talking about the EB-5 Investor Green Card Pathway and its rules and requirements. I'll just go over a few housekeeping items before we get started. Some of you may already know that Scott Legal, the firm, was founded on an E2 treaty investor visa several years ago. Our founder, Ian Scott, is actually in the United States on an E2 visa and has been on several different visas, including F1, TN, B visa, and H1B. As such, we do know what you are going through. Scott Legal PC is a full service immigration law firm, and we offer immigration services in a number of different areas, including E2 visas, E1, TN, L1, family immigration, EB2 national interest waivers, EB5 investor green cards, of course, extraordinary ability visas such as the O1, EB1, and more. And we have handled a wide variety of EB5 cases. We will be continuing this webinar series, and we are doing at least 2 webinars a week on many different topics regarding immigration law. And at the end of this webinar, we will be sending out several useful tools for all participants. First, we will send you a copy of the PowerPoint presentation that we will go through today. We will also send you a link that you can follow to download a guide that goes through the visa option in more detail. We will also send you a link that you can follow to sign up for any of the upcoming additional webinars in the future. We will also be recording this webinar, and we will be making this available on YouTube. We will also send you the link for that. So we do encourage you to subscribe to our YouTube channel and hit the notification button, as we do regularly upload a variety of immigration related videos that can be helpful to you. We will also finally send you a link that you can follow to set up a consultation with one of us, should you wish to discuss your case in further detail. So today we are very, very lucky to have Ian Scott, the founder and managing partner of Scott Legal PC, to present today. He graduated from Harvard Law School and have extensive experience in processing a wide variety of EB-5 petitions. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, let us get started with the webinar.
Excellent. Thank you very much, GA. It's great to be here and great to talk about EB-5s and the different options available to everyone. So the first thing that we're going to talk about is we're going to take a look at the typical profile of an investor. So with the EB-5 program, there are really 2 ways to invest. There's one which is investing through a regional center, and the other is investing through what is called the direct investment mechanism. Now, when you're looking at these 2 options, the profiles of the people who want to do this type of investment, they really are quite a bit different. So when someone is looking at investing in a regional center, typically this person has the profile of someone who wants to do a fairly passive investment. They don't really mind, fairly significant administrative fees associated with the investment, because when you look at a regional center, they typically have $35,000 to $50,000 administration fee, and with that, the return is actually quite low, and in a lot of cases, it's actually a negative return. So the main objective of this type of investor is to get the green card. The other thing is that these are projects. So an example of regional center might be the hotel chain that wants to raise $100 million and they're building a hotel and then they're raising capital from investors. That could be an example. But they are raising that capital and it is an investment just like any other investment. In investments, you can lose your money, right? So you could, invest the money that is required for the EB-5 in this investment, and you could lose your money and you may not get the green card. So those situations aren't that common, but it is something that you have to consider, that it is an investment just like any other investment. This particular program has 2 main components, one being the investment, the other being job creation. The regional center has the advantage that when you have a regional center EB-5, that you can include indirect jobs. So that hotel chain example that I used, let's say that as a result of that, down the street there was a dry cleaner, and further down the street there was a restaurant. You could make the argument that they're there because of the hotel. So That's indirect employment that's been created. Um, the regional centers as well are typically in what we call targeted employment areas. So the investment amount that you have to invest is lower, and we're going to talk about that in a little bit more detail. And this is the situation where the project supports multiple investors. So if the hotel chain, the example that I used, wants to raise $100 million, they would be able to get green cards for multiple people. And in contrast, when you look at the direct investment program, the entity can only get a green card for one person. So that's you can't do a pooling of three, four, five investors or more in the direct investment program. But the profile of a direct investor is someone who is an entrepreneur and really wants control over their company and their own destiny. They want control over the profits, they want control over running the business, who they hire, etc. And it does have potential for higher returns. Neither program allows you to guarantee any type of return or even guarantee the return of the investment. Neither program permits that. But if you are running your own business, and example of direct investment might be someone who is opening up a gym, for example, and they want to invest the money that's required for opening up that gym. And then they're going to meet the job creation requirement themselves. So they're not looking to anyone else for that support. And of course, there's no administration fee associated with that. With the direct investment program, only direct jobs can count. So when we say direct jobs, those are people who actually work at the company or entity, the EB-5 entity. So you can't count indirect employment for these other things that might be formed as a result of your business. The other thing with this program is it's a bit more stable because it doesn't require a reauthorization, and we're going to talk a little bit about that because the regional center program does require regular congressional reauthorization. And for some investors that have other a visa based on an investment program like E2, for example, they can count some of the, in some cases, as long as they meet the requirements, they can count some of the money that they've invested towards their current business, and they can count some of that when they're looking at the EB-5 investment amount. So those are some. So really, really two very different profiles that we see for people. That being said, that the regional center profile is the one that attracts probably 90% of the individuals who invest in the EB-5 program. So much smaller number of people that do direct investment, but our firm happens to process a lot of those direct investment EB-5s because we have a lot of people that are, for example, entrepreneurs, maybe on an E2 visa, and they're looking to move to a green card. So during the presentation, we're going to really touch on three key areas, and maybe even a fourth. We're going to talk about the investment that's required. We're going to talk about job creation and exactly what that means. And we're going to talk about exactly what it is that you have to file when you are processing an EB-5 petition. And probably the final thing that we're going to talk about is the regulatory policy mandates associated with EB-5. So one key aspect related to EB-5 is the investment. So you have to invest a bunch of money. So the investment amount is either going to be 800,000 or 1,050,000, and the amount is going to depend on whether or not you are investing in what's called a new commercial enterprise in a targeted employment area. So if you're investing in a new commercial enterprise, and new doesn't mean brand new, it can mean an entity that was created after 1990. If you're investing in a new commercial enterprise that's in a targeted employment area, then that investment amount is 800,000. And the targeted employment area means that the area is an area where the unemployment rate is at least 1.5 times the national average, or it's an area that is a rural area. So both of those meet the TEA, and then everyone else is going to have to invest the 1,050,000. So the investment, the examiners are extremely exacting with respect to the investment, and they do have a list of things that are excluded. So, for example, you can't include money that you pay for legal fees, or money that you pay for other administrative fees like accountants, et cetera, or money that you pay the administration fee related to the regional center, for example. So the 35 or $50,000 that you have to pay to invest in those programs. So those aren't, it's not 800,000 minus those. It's you would have to invest the 800,000 plus those. And the other thing, we'll talk about this a bit more later, but you do have to show where you got the money from for the 800,000 or the 1,050,000, but you also have to show where you got the money from for any of the other expenditures. So the administrative fee that you'd have to pay to a regional center or the legal fees that you would have to pay to a lawyer. So the a lot of people, as I said, move from E2 to EB-5. So they have an investment that they've made for E2. Sometimes they start an entity, and let's say they've invested $100,000 in that entity. Then they may be looking to move to EB-5. There are big differences between the E2 and the EB-5 when it comes to source of funds, though. Even though the regulations on paper, it looks like they're the same or similar, where the government basically says that you have to show that the money came from a legitimate source for both E2 and EB-5. The government says that. But the EB-5 source of funds analysis is more like an audit. So even if you've been approved, if you have an approved E2 and you have a source of funds analysis that has been approved, then that source of funds analysis would have to be revisited because under EB-5, they really do treat it more as an audit. So they're quite exacting and quite specific, and the one of the most significant portions of EB-5 is the source of funds, and you'll see this even when we're looking at regional centers. Sometimes regional centers will already have overall approval. So when they're adding new investors, the only thing that the immigration attorney is really looking at is the source of funds for the new investors. And that usually is quite a complicated exercise. The investment does have to be an equity investment. So whether it's a regional center or whether it's a direct investment, it has to be equity. So regional centers typically offer membership or partnership units rather. An equity investment, it could be a membership unit, it could be a partnership unit, it could be a share, but you couldn't, for example, loan money to a entity and then take back a particular note and then qualify for EB-5. So and as I said, the investment is one kind of key piece to the EB-5 program. The second big piece of the EB-5 program is job creation. So the key thing here is that the whether it's a regional center or whether it's the direct investment is that you have to create 10 full-time jobs per green card. So as we said earlier, when you're doing a direct investment, it's only going to be one green card per entity. That was a change made in 2022. And if you're doing a regional center, the regional center is going to have to create 10 full-time jobs. And if it's a regional center, then they're going to be able to include indirect employees. So the way that they do that is they get an economist to write an economist report, and the economist will say that as a result of this particular investment, the jobs that have been created, here are the direct jobs, and here are the indirect jobs. So those can count towards the 10 employees. The key thing to keep in mind here is that there is a link between the investment and job creation, or there has to be a link. So the money that's invested has to go towards creating jobs. So let's say that an entity already had 5 full-time people working there, and then someone invested the $800,000 in that entity. Those 5 full-time jobs that already existed you wouldn't be able to count those full-time jobs towards the 10 jobs. You would actually have to, you would actually have to create 10 new jobs. And similarly, this is why buying a business, so if you have a situation where you are purchasing a business under E2, that's completely fine. Like let's say someone's purchasing a restaurant and they paid $500,000 to purchase the restaurant. That's completely fine under E2. But under EB-5, it's not, because if the money is paid to the seller, then that money doesn't have anything to do with job creation. It's just money that was paid to the seller. So that 500,000 investment would not count towards the EB-5 investment. If the person was instead investing 500,000 into the restaurant, like so giving the money to the company and the company was put in the business bank account, then the employees that already worked for that restaurant, they wouldn't count in terms of inclusion towards job creation, but the investment would count, and then the person would still be responsible for creating 10 full-time jobs going forward. The other thing with the jobs is the jobs do have to be full-time jobs, full-time positions. There's something that talks about job sharing, and that which is not part-time job. It's completely different. But we tend to focus people on full-time jobs. So you should make sure that you are, if you're doing direct investment in particular, that you are registered with E-Verify so that you are sure that the people actually have work authorization. And with work authorization, what I mean is that they're US citizens or green card holders, because the 10 full-time jobs do have to be US citizens or green card holders, not just people who have work authorization. And then when we look at the EB-5 filing, when we're filing EB-5, we're going to file an I-526 or 526E, depending on whether or not it's a regional center or direct investment filing. It's quite a lengthy form that has all of the information related to the different things that we talked about. And then you are going to, depending on whether you're in the United States or outside of the United States, you're going to be filing an I-485 petition or doing consular processing. And then the decision on which one of those to file, typically, if you are a situation where you're investing 800,000, the category is current across all countries. So you would be able to file the I-485 concurrently in that situation. And if not, you'd have to wait for the category to become current. And then if you're outside of the United States, or you're in a situation where maybe you can't avoid traveling, because when you file an I-485, there's going to be a period of time that you're unable to travel, then the person may decide to do consular processing. And then finally, after 2 years after you have the green card, there is a petition called an I-829 that is filed, and the I-829 petition removes the condition. So the condition is that you created 10 full-time jobs, but you don't have to have created the 10 full-time jobs at the time of filing. So you file the I-829 petition actually showing that you actually have created the 10 full-time jobs. So the EB-5, there's an EB-5 Visa Reform Act that was implemented in 2022. And even though that seems like a long time ago, it seems like just yesterday that it was implemented. But it changed a number of different things. So it changed the lower investment for the TEA areas from 500,000 to 800,000. And it increased the higher investment threshold from 1 million to 1,050,000. So just an increase of $50,000 there, but a fairly significant increase on the lower threshold. And the regional center program is reauthorized until 2027. As I said before, the other program, the direct investment, doesn't have to be reauthorized, so that's ongoing. But when this happened last time, there was quite a bit of confusion with USCIS. So when the program had to be reauthorized last time, there was quite a bit of confusion with USCIS, such that the USCIS felt that they couldn't reauthorize or adjudicate any petitions when the program wasn't reauthorized. It wasn't clear whether they could or they couldn't, but they didn't. And so the good thing about this 2022 implementation said basically that if a petition is filed before September 30th, 2026, it will be adjudicated. And this helps with delays and uncertainty. There were also changes made to what constitutes a TEA. It makes it harder. The government's the only one now who can designate this, because there was a little bit of abuse that was happening with that before. So that change made it so that is not or cannot occur. Then the EB-5 project set aside. So this is very important for the practical aspect of whether or not the category is current. So if you are investing in a high unemployment area, so the 1.5 times the national average, or an infrastructure project, or a rural area, there are carve-outs that such that all of those categories are current. So that's why I said that for regional centers, they're always going to be in one of these areas, because if you're from certain countries, India and China, for example, the category is not current. All the other countries are current, but those countries are not current. So there could be quite lengthy delays. So people that applied before 2022 are still in a waiting pattern, whereas people that applied after 2022, even if they were from India or China and they applied to a project that was in one of these three areas, they were able to file the I-485 right away. So. The other changes in 2022, ability to file the 485 concurrently with the I-526. So that was a great change, because before that, you had to wait till the I-526 was approved. So, and this is particularly important because the I-526 takes a long time to be approved. It can be 4 to 5 years before it's approved. And so this makes it so that an individual who files an I-526 petition and an I-485 petition can stay in the United States and file for work and travel authorization without a problem. The We talked a little bit about source of funds. It's definitely not for the faint of heart. It's if you have a situation where you have savings, for example, the money's coming from savings from work, you not only have to provide the tax return showing that you lawfully earn those funds, but you would have to provide bank statements and show the accumulation of the funds over time, and then the money coming out of that bank account where the funds were accumulated over time. Similarly, if you have a collateralized loan, and this isn't something we would do for E2, but we have to do it for EB-5. If you have a collateralized loan, then you have to actually provide documentation showing where you got the money for the collateral, right? So it's quite an extensive exercise. They clarified loans and gifts because they were in the legislation. They wanted to, or they almost implemented it's something that said that gifts can only be from immediate family members, but they changed that. So the loans and gifts are both fine, but you do have to prove the source of funds for that. And then there was some procedures or policy or law put in that if the regional center fails or closes through no fault of the individual, that they do have some recourse, whereas that didn't exist before. So other considerations, the and this first bullet point really relates to the direct investment, and if the individual, because there's a case, it's called Matter of Ho, and the person invested 500, this is when the investment amount was 500,000. They invested $500,000 put it in a business bank account, then developed a 3-page business plan and then applied, and then they were denied and they appealed. But the appeal board said, no, it was a proper denial. And they said bunch of things. But one of the things they said is that it's not enough just to, invest with an intent to invest. You can't just put money in a bank account. They said if the person puts the money in the bank account, they could get the green card and they could just take the money out. So you do have to have spent money and or commitment. So it can be salary commitment, lease commitment, et cetera, if it's direct investment. If you're doing a regional center, you actually have to give the money to the regional center. Um, Loans and gifts, as I said before, you do have to show that the loan and gift has been the loans and gift have been where the money came from for those loans and gifts. And the other thing to remember is because the petitions are taking 4 to 5 years to be adjudicated, you also have to keep in mind that when they do come to the petition, they might ask, okay, show me the loan payment, or they might say, okay, it's a gift. Show me that you filed with tax authority that you made this gift, right? So you do have to make sure you're complying with local law because those things can really come back to bite you if you are not, right? Because they can just deny the petition and say that, okay, if you said it was a gift and you didn't pay a gift tax, then you lied. Wasn't really a gift. So we're going to deny the petition. The purchasing a business, I talked about that already. So, as I said, for E2, that's fine, but it can only work in very limited circumstances for EB-5. The other thing to kind of mention here is regional centers. You'll see this a lot. Sometimes regional centers or others will say, okay, well, you can make some of the investment now and some later. I'm definitely advised against that. There have been some recent, in particular, USCIS denials where they've said that actually is not appropriate. We've never advised clients to do that, but there's in one reading of the regulations, a very liberal one, that there may be a basis to suggest that that's possible. But especially these days when they're not even going to get to your petition 4 or 5 years down the road, you'd hate for them to get to it and then just deny outright. And those petitions they denied outright. I don't even think they issued a RFE or a notice of intent to deny. There's no amount that you have to own, unlike E2. You can own a fraction of a percentage, and you can't, as I said, have any type of guaranteed return. And we talked a little bit about the differences between E2 and EB-5. So one another difference is that E2 does require that you own at least 50% of the entity if you're an investor. And we talked about administrative fees not being able to count. And E2 is flexible with job creation, where they allow you to, you could have even 3 employees or maybe even a little less and still qualify. Whereas with EB-5, it's a very specific number. And we talked a little bit about buying a business already. And I think we'll skip through this one. Perfect. So what else should you be aware of? So timing considerations. EB-5 program takes a long time. So it can take 4 to 5 years for an I-526 petition to be approved. There's a little faster with some that are done in rural areas. But you have to keep that in mind. And with that, you have to make sure that you're keeping some type of underlying status during that period of time. There are country specific quotas or levels. Like we talked a little bit about that with China and India, where if you're not applying under the carve outs, and those carve outs will move to not being current probably soon. So that's something to consider as well. And you do like we have some clients that maybe are on an E2 and they do EB-5. They're in the United States and they're eligible to file an I-485, but they don't because the reason they don't is because they can't be in a position where they can't travel because when you file an I-485, you are in a position where you have a good amount of time, maybe 9 months, where you're unable to travel until you get travel authorization. Then when you're looking at this, when you're looking at, making sure that you're keeping your underlying status, you have to look at, well, what type of visa do I have, right? Do I have a TN? Do I have an E2, which are both single intent visas? Or do I have an H1B or an L1, which allows dual intent, so may provide for more flexibility? So you do have to just make sure that, especially if you have to renew the visa, right? So if you're on a TN and you're in the United States, and you have an I-485 filed, you couldn't file an extension for that TN in the US, for example. You could do it for E2, but not for TN. And then sometimes people do have parallel green card strategies. Especially given the EB-5 takes so long, we have people we had one case where the person applied for an NIW and then also applied for EB-5. The NIW was more of a longer shot, I think, but then the NIW ended up getting approved right away so that the person didn't need the EB-5 and NIW. Almost any petition is better than any green card petition almost is better than EB-5 because you don't have to worry about removing the conditions on any other employment-based green card category, right? So you're out of the system faster, and every other employment-based green card category is faster than EB-5 because most of them have expedited processing available. So sometimes people do have parallel green card strategies to cover their bets, and planning is really the key with respect to this. Perfect. And I think that that is it. And I'll turn it to GA if there are any questions.
Yeah, thank you so much, Ian, for all of the insight. Very helpful. Now, there's just one question that came in.
Perfect.
Let's take a look. Do we have experience with investments funded from an SDIRA?
Yeah, I don't. If maybe I don't know. I don't because I'm not sure what that is. But maybe because I don't know what it is, I'd say I'll just leave it at no with that. But the key thing though is the investment because there are lots of different financial products out there. The key is that you personally are making the investment. EB-5 is very strict. Like you can't invest through an entity, you can't invest through a trust. You personally have to be making the investment. So much so that the money has to be sitting in your personal bank account before it's transferred anywhere. Like a long time ago, USCIS used to deny petitions where, let's say that someone investing in a regional center and a parent that was sponsoring something for a child, and they didn't want to put the money in the child's bank account even for a day because the child's, over 18 and who knows what's going to happen to it. So they just transferred the money directly to the regional center and gave a gift letter to the child. And USCIS denied those petitions, saying that the child didn't ever have possession and control of the funds, right? So they can be quite exacting. So depending on what the product is, there's lots of different things out there, but depending on what the product is, it has to meet the kind of key requirements that it was personally invested by you.
All right, so we have another question that just came in. Timing questions.
Sure.
Is the fastest route to conditional green card a rural project, fully funded investment with concurrent filing? And based on recent experience, how long is this taking lately? I guess generally we can just
Yeah.
talk about the processing times.
Yeah, absolutely. So that if you invest in a rural project and look, so when you're looking at a rural project though, it has to be a rural project that is quite specific. So if you're investing, for example, in an regional center, it's a rural project where the project has a specific rural designation approval. Because sometimes the project will say this is a rural project, but they don't have that. I think it's 9526. I can't remember the number, but there's a very specific approval. Now, for those projects you can see approvals of I-526 approvals within 6 months to a year, right? So then you have to the I-485 approval, and that might be 18 months or could be sooner, could be even 3 months. So, but as I said, you have to be careful because you have to be asking the regional center the right questions because that could be faster. Now, the general processing times, though, they can be anywhere from a year and a half to what's much more common, 4 to 5 years. So last year we had a direct investment that wasn't a rural area that was approved in about a year and a half. Very uncommon though. It was shocking that they got to it that quickly. But we have clients that have been waiting for 4 years and have still not, they have not gotten to their petitions yet.
All right, so I think that was all of the all of the questions that came in at this
Perfect.
point. Yeah, thank you so much, Ian. I'm sure this was
Excellent.
very helpful for our attendees, and yeah, and
Perfect.
please feel free, everyone, to sign up for any of the upcoming webinars in the future. And if you'd like to discuss your case in further detail, please do not hesitate to reach out to us for a consultation.
Great. Excellent. Thank you, GA. Thank you, everyone, for joining.
Thank
Bye-bye.
you.